Hello, thanks for tuning in. My name is Rachel Turpin and I'm the Tukwila City Attorney. The purpose of this presentation is to give an overview of the City of Tukwila's Code of Ethics for employees and appointed officials. The city's Code of Ethics is codified at Chapter 2.95 of the Tukwila Municipal Code. Chapter 2.95 applies to only employees and appointed officials. There's a separate chapter of the TMC dedicated to elected officials. TMC 2.95 begins by outlining the purpose of the city's Code of Ethics. And that purpose is to uphold and promote the highest ethical standards and to protect the public from decisions that are affected by undue influence, conflicts of interest, or other violations of the Code of Ethics. The TMC does note that interpretation of TMC 2.95 is to be guided by common sense and practicality. TMC 2.95 outlines 12 ways in which the Code of Ethics can be violated. The first is simply a general prohibition against conflicts of interest. For example, let's say you're on the Arts Commission and you're in the process of selecting an installment for a new city park. One of the artists that's up for selection is your daughter. Even if you have absolutely no financial ties to your daughter whatsoever, voting to select her installment may be seen as conflicting with your official city business. Therefore, you might want to recuse yourself from such a vote. The second violation outlined in the Code of Ethics is having a beneficial interest in contracts. This is not likely to come up with appointed officials as they don't generally approve contracts. However, a number of city employees do have contracting authority. Building off of our last example, let's say that the artist recommended by the Arts Commission is not a commissioner's daughter, but instead is the Parks and Recreation Director's wife. The director would not be able to enter into a contract with her to produce the work. Please note that this prohibition does not apply when the employee or official has a remote interest. The code defines a remote interest as that of a non-salaried officer of a nonprofit corporation, which would basically be an unpaid board member, an employee of a contracting party where that employee's compensation is fixed. In other words, they wouldn't be able to get a bonus from bringing in this contract. The landlord or tenant of the contracting party, so if the staff member or appointed official is a landlord or tenant, that would be considered a remote interest. Or if the employee or appointed official is the holder of less than 1% of the shares of the contracting party's company. Please note that the fact and extent of such an interest must be disclosed and noted in the minutes prior to formation of the contract. In addition to the prohibition on beneficial interest in contracts, there's a related prohibition on beneficial interest in contract selection. For example, let's say that you're on the Human Services Advisory Board. The city is considering contracting with a local company in which you're a shareholder. Even if you will not be voting on or otherwise responsive for entering into the contract, it would be improper for you to lobby the mayor or city council to select your company. Once again, this doesn't apply to remote interests as defined on the previous slide. Representing a private individual at a city proceeding is also a violation of the Code of Ethics. Let's say you're an attorney and a member of the Equity and Diversity Commission. A Tukwila employee has been fired and would like to hire you to represent them in an employment discrimination lawsuit against the city. You would not be able to take this person's case because doing so would require you to appear in court on this individual's behalf. Please note there are a couple exceptions to this prohibition. You can appear on your own behalf or on behalf of an immediate family member, and you can appear when directed to do so by a subpoena. The Code of Ethics also prohibits certain private employment. For example, let's say you work as a project manager and you're a member of the Planning Commission. A local developer would like to hire you to manage a project located in Tukwila. The project's just underway, and your job would entail making a number of zoning and permit applications to the city. This would violate this provision of the Code of Ethics, as it's likely that this employment would impair your independent judgment or be incompatible with proper discharge of your planning commission duties. Holding a beneficial interest in legislation is also a violation of the Code of Ethics. There are not a lot of instances where this is going to come up for appointed officials and employees. An example would be if you are a member of the Planning Commission and an ordinance is before you that, if approved, would dramatically reduce your property value. You would not want to vote on it, or you would risk being in violation of this TMC. Once again, this doesn't apply to remote interests, but like previously stated with remote interests, the fact and extent of your remote interest must be disclosed and noted in the minutes prior to consideration by the Planning Commission. Disclosure of confidential information is another means of violating the Code of Ethics. As an employee or appointed official, you can't share any confidential information that you obtain in your role as employee or appointed official. The most common example of a violation of this section would be forwarding on an attorney-client privileged email that you received to someone that's outside of the city. Improper use of your position is also prohibited. You may not knowingly use your position to secure personal benefit, gain, or profit, or to secure special privileges or exceptions. Let's say you're a member of the Community-Oriented Policing Advisory Board and you receive a speeding ticket while driving through the city. When the officer approaches you, you would not want to mention your role on the advisory board or say anything like, "Just wait until I talk to the chief." You would just want to accept your ticket and either pay it or contest it just like anyone else would. Improper use of city personnel is also prohibited. For example, you can't come in and ask the front counter staff to make copies of your real estate flyers or to run errands for you. Pretty straightforward. Similarly, improper use of city property is prohibited. You can't use city vehicles, equipment, materials, money, or property for personal or private convenience or profit. For example, let's say you buy a new sofa, you can't come borrow a city vehicle to transport it to your house. This doesn't apply to services that are available to the general public, use of this property for authorized conduct of city business, or other uses that are approved by administrative order of the mayor or the city council, and it doesn't apply to participation in the city carpooling program. Acceptance of compensation, gifts, favors, rewards, or gratuity is also prohibited by the city's Code of Ethics. This means that you may not accept directly or indirectly any compensation, gift, favor, reward, or gratuity for a matter connected with or related to your services with the city. There are some exceptions to this prohibition on accepting gifts, however. Attendance at a hosted meal when it's provided in conjunction with a meeting directly related to official city business, or where official attendance by a city representative is appropriate, is not a violation of the Code of Ethics. Acceptance of an award publicly presented in recognition of public service is not a violation, nor is any gift valued at $100 or less, which cannot be reasonably presumed to influence your vote, action, judgment, or considered a reward for inaction or action on a city matter. Your ethical obligations to the city do not necessarily cease after you leave city service. You are still prohibited from disclosing any privileged, confidential, or proprietary information you gain from your position. In addition, for a period of 1 year after leaving city service, and for any matter in which you personally and substantially participated, you may not assist any other person in that matter, represent another person as an advocate in that matter, or participate as or with a bidder, vendor, or consultant in any competitive selection process for a contract related to that matter. Now I'm going to go through some examples of how to apply the Code of Ethics. Let's say you're having coffee with several friends. They've heard rumors about a city project that's being developed and they want to know if it's true. The only information that you've received about this proposal is from an attorney-client privileged email. Your response to your friends is only, yes, there is a proposed project, but you give no detail. Is this a violation? Well, you can't divulge any information that you learned strictly from the attorney's email. You can, however, provide any information that would be available to the public upon request. Let's say you've been running around all day and you get to City Hall just in time for your meeting. You haven't had time to eat, so you ask the front counter staff if they would run out and grab you something. You give them some cash to do so. Is this a violation? Yes, this would be an improper use of city personnel, even if you give them the money for the food. Okay, you're a commission member and you work for an engineering consulting firm that is seeking a contract award from the city. You run into the public works director and begin singing the praises of your company and telling him all the reasons that they should select your firm. Have you violated the Code of Ethics? Well, it really depends on how you are paid by that engineering consulting firm. It's probably okay for you to do this if your compensation is comprised of fixed wages and salary only. However, this is an area where everyone should probably use caution and avoid any sort of appearance of impropriety. Let's say you were recently appointed to the Human Services Commission. An applicant for funding offers to take you to lunch to discuss their programs. Can you accept? Probably not. Even if the value of the meal is under $100, accepting the lunch may be perceived to influence your vote on their funding application. It's probably better just not to accept it. Let's say you attend a seminar that was paid for by the city. As part of your participation at the seminar, you were given a t-shirt and some golf balls. Can you keep these items? Yes. If they're under $100, there's no way that they can be perceived as a reward for action or inaction, then you certainly can. Now I'm going to talk a little bit about the complaint process itself. A complaint that the city's Code of Ethics has been violated can be filed with the mayor or the city attorney. The mayor must promptly designate an investigator to look into the allegations. The investigator must complete their investigation and prepare written findings and conclusions within 60 days of the date that the complaint was received. Within 5 business days of receipt of the investigator's report, the mayor must prepare a written recommended disposition of the complaint. Copies of this recommendation, as well as the investigator's findings and conclusions, are then sent to the subject of the complaint as well as to the complaining party. The issue is also placed on the agenda of the next regularly scheduled council meeting for informational purposes only. To appeal the mayor's recommended disposition, the subject of the complaint may file a written request for a formal hearing before the city's hearing examiner within 10 business days following the date of the recommended disposition. The hearing is then scheduled to take place between 20 and 60 days later. Within 30 days of the conclusion of the hearing examiner prepares findings of fact, conclusions of law, and his or her order. Copies of these documents are then sent to the subject of the complaint as well as to the complaining party. And once again, the matter is placed on the agenda of the next regularly scheduled council meeting for informational purposes. There are several penalties for violating the Code of Ethics, and they really depend on the nature of the complaint. They include cease and desist order, order to disclose documents or information, exclusion from bidding on city contracts for up to 5 years, termination or invalidation of contracts entered into inappropriately, civil penalty of up to $1,000, an admonishment, reprimand, or censure. If the subject of the complaint is unsatisfied with the hearing examiner's order, he or she has several other avenues of appeal. Civil penalties may be appealed to the Tukwila Municipal Court. Cease and desist orders and orders to disclose may be reviewed by seeking a writ of review in King County Superior Court. For all other penalties, the subject of complaint may seek whatever remedies exist at law or in equity. Also relevant to many boards and commission members is the city's Board of Ethics, which was created in 2014. The board is comprised of the chairs of each of the city's 5 standing commissions: the Planning Commission, Arts Commission, Parks Commission, Equity and Diversity Commission, and the Civil Service Commission. If the chair is unwilling or unable to serve, the commission may select another member to serve on the Board of Ethics. The purpose of the board is to review ethics complaints against elected officials for determination of sufficiency before an investigation is initiated, and to adjudicate ethics complaints and to provide advisory opinions for elected officials upon request. The board must only meet as frequently as it deems necessary, which in practicality will likely be when ethics complaints are filed. A majority of the board constitutes a quorum, and the board can adopt its own operating procedures as long as they are not inconsistent with the Tukwila Municipal Code. The city attorney or independent legal counsel is available to advise the board. The Board of Ethics reviews complaints against elected officials only. It does not handle complaints against employees or appointed officials, such as boards and commission members. Complaints received by the mayor, city attorney, or council president are forwarded to the Board of Ethics in writing. The board then reviews the complaint for a sufficiency determination. After reviewing the complaint, the board may determine that, even assuming that the facts in the complaint are true, a violation has not occurred. They can determine that even if the facts in the complaint are true, a violation has occurred, but that such violation is not material, was inadvertent, or has been adequately cured. Or they can make a preliminary determination that the facts, if true, could potentially constitute a violation. The board shall submit a written report with findings within 10 days of receipt of the complaint. This constitutes the board's determination of sufficiency. If the board finds that a complaint is sufficient, it moves on to the next stages of the process. If the board finds that the complaint is insufficient, no further action is taken. The board's determination of sufficiency is final and not subject to appeal. If the Board of Ethics finds that the complaint is insufficient, no further action is taken. However, if the board finds that the complaint is sufficient, meaning that it may constitute a violation of the Code of Ethics, then they notify the city attorney, who then designates an investigator. The investigator completes his or her own investigation and drafts findings and conclusions, which are then provided to the city attorney. The city attorney forwards a copy of the investigation and the findings and conclusions to the Board of Ethics within 5 business days of receipt. Copies are also sent to the complaining party and the party that is being complained against. Within 10 business days of receipt of the investigation, the Board of Ethics must convene and review the complaint, findings, conclusions, and the recommended disposition. When reviewing the investigator's findings and conclusions, the board has several options. They could review them and determine that a violation has not occurred. They can determine that a violation has occurred, or they can convene a hearing to take additional evidence. Once the board has made its final determination, it issues its own written findings of fact and conclusions of law, as well as a recommended disposition. Copies of those are provided to the complaining party complained against, the city attorney, and to the city council, and placed on the next regularly scheduled city council meeting agenda for discussion and disposition. And that concludes this training on the City of Tukwila's Code of Ethics. Please remember that if you ever have any questions or concerns regarding the applicability or interpretation of the Code of Ethics, you can always contact the City Attorney's Office for advice. Thank you.